Dr. Russell Norman.
E te mangai o te whare tēnā koe.
Tēnā koe.
3 years ago, I had the benefit, I guess, of being able to spend a day in the Fukushima exclusion zone, which is the 25-kilometre radius zone around the Fukushima nuclear power plant. And within that zone in crowded Japan, nobody was allowed to live because of the radiation, the contamination from the explosion in Fukushima. Going around that zone was extraordinary because Japan is so crowded and there was nobody there, the abandoned rice paddies, the abandoned villages and so forth. And you got a real sense of the genuine dangers of nuclear power in that context. And the German government took note of the Fukushima disaster and made a decision that they would phase out nuclear power, which is their democratic right. It was passed through the Bundestag, the German parliament, and a decision over time to phase out nuclear power. Now this, it seems to me, coming from nuclear-free New Zealand, seems a perfectly reasonable position for a democratic parliament to take. The problem was that Germany had signed an investment treaty with Sweden, which had an investor-state dispute settlement clause within it. And so a Swedish nuclear power station operator decided that they would take a case against Germany for about 7 billion New Zealand dollars, an investor-state dispute settlement case. They were suing the German government because the German government had the temerity to democratically decide that it wanted to phase out nuclear power. Now, this is a classic problem with investor-state disputes clauses, is that they give investors special rights to sue governments in secret tribunals for very large compensations. The biggest case that we know of is 1.3 billion US dollars awarded against Ecuador. The reason why Vattenfall, the power company, was so confident in its case, this case is ongoing against the German government, was because Vattenfall had previously taken on the German government over a coal-fired power plant, where Hamburg, where the plant was to be built, had put a whole bunch of environmental protections on the plant, a whole bunch of environmental rules around the new coal plant, which were designed to protect the Elbe River. Now, Vattenfall, the Swedish power company, did not like these environmental rules, and so it sued the German government, the German federal government, under investor-state dispute settlement clauses for a little over 1 billion euros. Now, the German government settled out of court. Now, you might say, oh, well, that proves that Vattenfall didn't win. Well, in fact, they did win, because the settlement out of court was that Hamburg had to remove all of the environmental constraints. And that is a classic example of how investor-state disputes clauses undermine the ability of governments to regulate, to protect the environment. This is just one case amongst hundreds. These cases are now multiplying. There's more cases than ever every year, investor-state disputes clauses. The problem with these is that there is no kind of international court that you can go to. You go to a 3-person panel, a tribunal, one person appointed by the company, one by the government, and one agreed in the middle. The decisions of these tribunals are binding. There is no appeal. The proceedings happen in secret, literally in secret. Often people don't know until some time afterwards what the decision was, how much the costs were that were awarded. And so the impact of these is a chilling effect on regulation, the regulation by governments in order to protect human health and the environment. This is why the European Union Trade Commissioner has now come out and said these clauses are no longer fit for purpose in the 21st century and will not sign up to the TTIP, which is the equivalent agreement to the TTP, if you like, between Europe and the United States. The obstacle to signing that at the moment is the ISDS clauses, because the Europeans are saying we will not sign up to these clauses which prevent our governments from regulating to protect the environment or human health or anything else. Let's remember Egypt was sued because it raised the minimum wage in one of these cases. So these clauses are a fundamental constraint on democratic regulation, and that is why they're so problematic in the TPP. The clause that Tim Grosser is so keen to sign up to in the TPP is exactly the clause that the EU Commissioner described as no longer fit for purpose in the 21st century. That's the clause that the EU refuses to sign, and Tim Grosser is rushing in to sign it. And what's it all for? Well, according to the US Department of Agriculture, if New Zealand gets everything it wants in the TPP, all the agricultural tariffs are removed, all the agricultural trade-related quotas are removed, New Zealand's GDP will increase by 0.01% in 2025. And for that, we're willing to trade our right to pass democratic law to protect the environment and human health. That's a bad deal.